Hi, I'm John from Launch, Small Business Legal Services Done Differently. I get asked a lot of questions about arbitration clauses and contracts. Why are they in there? What do they mean? I thought I'd share a little bit of information about arbitration clauses. So basically, it's a clause in a contract that says any dispute will be handled by arbitration as opposed to going through the court system. Typically, people try to add them in there because they consider it a less expensive and faster way to resolve a dispute. However, be aware that's not necessarily going to be the case. So there are pros and cons associated with arbitration. On the pro side, arbitration is usually more private than a trial or a court proceeding, and it's less formal. Also, an arbitrator may allow more evidence in, such as testimony and documents, to be considered when resolving the issue, things that a judge might not allow into a courtroom or in front of a jury. On the con side, there's a possibility of reduced discovery, meaning you may not be able to get as much information in as you would in a court situation, since some of those rules aren't going to be the same. Also, the decision in arbitration is likely going to be final, so you're not going to have an option to appeal it. And finally, decisions can be more subjective in arbitration and not necessarily supported by the law or precedent, and more along the lines of what the arbitrator thinks is fair. So it could limit some of your options. Bottom line, I think it's arbitration clauses should be carefully reviewed and understood before just simply agreeing to them. They've become commonplace in contracts, so keep an eye out for those.